Dear learners, today in my lecture I would like to discuss another topic that is law of preemption or haqq sufa. This is also known as haqq sufa, haqq sufa, preemption, right of preemption or haqq sufa. Friends, as it may be clear that under Muslim law, one who is owner of the property is competent to dispose of his property or ownership in the property by different mode or different means, such as one can transfer his property by means of sale, by means of gift, and by means of wasiyat. All these points have points, and this mode of the transfer, these mode of the transfers I have already discussed. This is basically the fundamental or basic right of the owner in respect of his property, that at any point of the time, if he desires, he can dispose of it or can make the disposition of the property either by way of the sale or by way of the gift or by way of the wasiyat or testament. It has also been clarified that in case a disposition is made by means of the sale, on the completion of the formalities for sale, the property will devolve from one person to another person, that is from the vendor to the vendee, and on the completion of the formalities, the purchaser will become the real owner of the property as it was with the transferor before completion of the formalities. So there is immediate transfer of the ownership in the case of disposition by sale. Then I told that almost uh, in the uh, disposition by a gift or inter vivas or hiba, also the ownership in the property purposed to be gifted stand immediately transferred, that is on the delivery of the possession of the subject matter of the gift by the donor to the donee. Donee become the real owner of the property as donor was immediately before the delivery of the possession, and thereafter the gift also becomes irrevocable. Uh, all these points I have already made clear. And then I have already discussed that in case of the bequest, bequest is executed by the owner in his life, but ownership rights uh, get vested in the legatee only on the death of the testator. However, these are the fair absolute right of the seller, donor, and testator. So far as limitations are concerned, there are certain limitations, but limitations operate only as per rules governing the devolution of the property, maybe the sale, maybe the gift, maybe wasiyat. Otherwise, as a general principle, one who is the owner of the property, he is authorized by law to dispose of his or her property the way he likes, means he can dispose of it by uh, resorting to the different means or modes of the transfers recognized under the laws, that is under the Muslim personal law. Now today I am coming to discuss are going to discuss preemption or law of the preemption, which is also known as haq-e sufa, haq-e haq e sufa. That is, haq means right, and sufa means preemption. And therefore, when this Arabic term haq sufa is translated into English, it means a right of preemption. Ladies and gentlemen, the law of the preemption is or haq sufa is essentially a part of Islamic jurisprudence or Muslim law. It was this concept of the preemption or haq sufa was uh, introduced on the basis of certain saying or traditions of the Holy Prophet. And therefore, this part of the Muslim law, that is right of the preemption, is as old as the Islamic legal system itself. Because the genesis of this right basically are traced into sayings of the Holy Prophet. Therefore, from the lifetime of the Holy Prophet, or in the lifetime of the Holy Prophet, this right was came into existence, was put into practice, was introduced by the on the basis of saying of the Holy Prophet. Therefore, it is said that this is essentially the integral part of the Islamic legal system dealing with the devolution of the interest of a Muslim in his or her specific property. Ladies and gentlemen, of course, this lies as old as the religion of the Islam itself. And Islam spread over the period, and it moved from the uh, boundaries of Arab to some other countries like India. It came in India later on. Therefore, the concept or right of the preemption was introduced in India by the Muslim judges during the British period, who were bound to administer Mohammedan law, but it was unknown in India before the arrival of the Mughal ruler. Therefore, historically speaking, since the law of the preemption is considered essentially the part of the Muslim law, because it is directly connected to the historical background of the Muslim law or historical background of the Islamic legal system. Therefore, when the Mughal invaded the India, established their rule and the administration of the justice, uh, during the Mughal period, law of preemption was introduced for the first time in India. And in the course of the administration of the justice, Mughal period legal system basically started deciding many cases on the basis of the preemption or haqq sufa. Therefore, it is stated historically that during the Mughal period, law preemption grew in villages and was adopted by the village communities as customary law based on their mutual convenience. So, in fact, during the Mughal period, the Mughal rulers, uh, uh, in the course of the administration of the justice, made an attempt to introduce the law of the preemption as part of the Muslim personal law or as a part of the Islamic legal system. But due to certain reasons, this law of the preemption was taken by the villagers, and they started applying in their uh, cases. But the law of the preemption during the Mughal period was adopted particularly in the villages by the village communities, not as part of the Muslim personal law or Islamic legal system, but basically they started exercising this right as part of their customary law based on the mutual convenience. But uh, in fact, law of the preemption or haqq sufa was introduced and applied in practice not as part of the customary law but as part of the Islamic law uh, based on the saying of the Holy Prophet. So, in fact, therefore, it is stated that for the first time, uh, law of the preemption or haqq sufa as part of the Islamic legal system or Muslim law for the first time was introduced during the British period through the courts or through the judgments delivered by the judges. It is based upon the text of the Muslim law and it is well-founded doctrine in India. The object of the law of the preemption of Haqq Sufa is very philosophical and social oriented. In fact, the object of the preemption is stated to be as a measure, as a legal measure to prevent the introduction of a stranger among the co-sharers, participators in the appendage and neighbors, so that no inconvenience and disturbance is caused to them. During the British administration, the law of the preemption became and remained for certain uh, time as a common law of the country, and it was applied universally to both the Hindus and Muslims. Ladies and gentlemen, uh, here the the fundamental object or purpose of this preemption law is or haqq sufa is to prevent the introduction of stranger among the co-sharers, participators in appendix and neighbors. And the philosophy of this law is to avoid inconveniences and disturbance caused to them because of the entry of a new owner in the property in which one is already in possession. But this law for a longer period of time was exercised as part of the common law or customary law of the country, since it was exercised or invoked and applied as a essential part of the customary law of the country. Therefore, it was made applicable to all the peoples across the religion, maybe Hindu or maybe Muslim. Both were uh, uh, invoking this law of the preemptions in cases of the inconveniences. Basically, I have already told that preemption is a right which is rooted in the history of the Islam, in the sense that this law was directly introduced by the Holy Prophet from his own mouth, that is in the form of the tradition. It was adopted by the Islam in general, uh, introduction of the stranger among co-sharers, neighbors, to cause the inconveniences and vexation. Basically, I have already said that origin of the law of Sufa or Hakke Sufa is deeply rooted in the saying of the Holy Prophet. The Holy Prophet is reported to have said, "He who sells his house should convey his intention of it to his partner." There is another tradition to the effect which is reported from a companion of the Holy Prophet, and the companion of the Holy Prophet is reported to have said that he who has an orchard or land should not sell it till he informs his partner of it. This is another tradition or saying of the Holy Prophet, giving rise to the concept of the law of preemption or Hakke Sufa. There is another tradition reported from another companion of the Holy Prophet, and Ibn Abbas is reported to have said on the authority of the Holy Prophet, "He who possesses some land and wants to sell it should inform his neighbor first of this." Further, it is reported to have Abu Raif Rafi, he is one of the companions of the Holy Prophet. He is also reported to have said that Holy Prophet said, "The neighbor has best to purchase his neighbor's estate by reason of being nearby." Therefore, ladies and gentlemen, neighbor is said to be the best person to purchase the property of his neighbor. And therefore, if without informing of this right, one neighbor has sold his property, then the other neighbor who is either co-sharer, appendage, participator in the appendage and other benefits, he will be called as entitled to the Haqqe Sufa. Thus, the genesis of Haqqe Sufa basically is purely Islamic. But the right of the pre-emption was unknown in India until the arrival of the Mughal emperors. During the Mughal emperors, the right of pre-emption in village and was adopted by the village communities as customary law based on the mutual inconvenience. Privy Council in Kumar Digambar Singh versus Ahmed Saeed Khan, EIR 1919, EIR 1915, has thrown the light on the historical origin of law preemption. While tracing the history of law of the preemption, the Privy Council in Digambar versus Ahmed Saeed Khan, year 1915, threw some light on historical origin of law preemption in this case. And the court tracing the history of the law preemption observed that, I quote, "In British India, it was right of a group of the people to take over the property of the village in exercise of the rule given under the Muslim law. Gradually, it developed into the form of customary law, and customary form it spread over in some Muslim areas. Therefore, now it is necessary to know what is the meaning of the law of the preemption or what is the meaning of Haqqe Sufa. Ladies and gentlemen, the sufa is an Arabic word which means conjunction. Hakke sufa is right of the owner of the property which the adjacent to are in conjunction with another property. Hakke sufa is a right to acquire the neighboring property at later stage from first purchaser. It is a right to subsequent purchaser of the property adjacent to own from another fresh purchaser. It is a right to dislodge the ascertained. It is a right to dislodge a stranger entering into the one's neighborhood. Thus, the law of pre-emption is defined as a right which the owner of certain immovable property possesses as such for the quiet enjoyment of that immovable property to obtain the substitution for that immovable property to obtain a substitute for the buyer proprietary possession of certain other immovable properties not his own on such terms as those on which such later immovable property is sold to another person. Thus, the preemption is the right which the owner of any movable property possesses to acquire another immovable property for the price for which it has been sold to another person. Justice Mahmood in Abdul Justice Mahmood defines the term preemption. And according to Justice Mahmood, sufa is a right which the owner of certain immovable property possesses. And this observation was made by Justice Mahmood in Govind Dayal versus Inayatullah case. In Govind Dayal versus Inayatullah, the Allahabad High Court, speaking through Justice Mahmood, held that right sufa is a right which the owner of certain immovable property to obtain in substitution for the buyer proprietary possession of certain other immovable property not his own on such terms as those on which such later immovable property is sold to another person. Another authority, Mullah, he defines, according to him, the right of sufa or preemption is a right which the owner of any immovable property possesses to acquire by another immovable property which has been sold to another property has been sold to another person. Thus, the definition as it stands seems very difficult and complicated, but is most scientific and comprehensive. Therefore, main limbs or ingredients of the definition of sufa are: number one, preemption is a right which the owner of certain immovable property possesses to obtain quiet possession of certain other immovable property not his own. The right is obtained in substitution for buyer who has already purchased that immovable property. Third, the right of property purchase is obtained in one same terms which that other immovable property is sold to purchaser. The right is gifted by law for quiet enjoyment of the property. So, gentlemen, the word sufa has also been defined by another authority, that is Mullah. And according to him, the sufa or right of the preemption is a right obtained by the owner of an immovable property by purchasing another immovable property that has been sold to the others. It gives the person priority over the property already sold by the owner and can be claimed by paying the same price as would have been paid by another owner. So, what is in plain words, what is sufa, or what is the preemption, or what is the right of the preemption? Basically, a right of the preemption is a right which the owner of an immovable property possesses to obtain in substitution another immovable property which has already been sold by paying the same price to the vendee for which the property was sold to him. For example, this just I am giving the example, you understand it. Say for example, this is the one property, and this is now another property. Now A is the owner of this part of the property. Say for example, this is the property X, and B is the owner of this property, this piece of the land or property which is designated as property Y. So there are the two properties here. One property is A and other property is B. One property is X and the other property is Y. X property is owned by a person A, and B is the owner of the property Y. Both the properties are in conjunction. That is, they are adjoining to each other. By location, they are uh, uh, in conjunction or adjoined with each other, A and X and Y, and this is the property. Now, law of the preemption requires, Muslim law of the preemption requires or provide the rule that out of these two owners of the different properties adjacent to each other, if either of them is wishing to sell his property for whatever price he wants to sell it, first of all he is required or he is supposed to make the offer of the sale to his neighbor or the owner of the property which is adjacent to him. For example, if A is wishing to sell his property X, then he must inform his intention of selling to his neighbor who is the owner of the adjoining property Y. If A, without making the offer of the sale first to the B, that is the owner of the adjoining property, has sold his property to another person, to a stranger, say for example C. Now here in this case there are three parties. A is the owner of a plot of the land. Adjacent to this plot of the land there is another plot called as Y, plot X and plot Y. Owner A of plot X, owner B of plot Y. Now if A fails to inform that he is wishing or he is going to sell his piece of the land to B, and without giving any information to B about the sale, he has sold the property to C and has executed a sale deed. For example, sale deed is executed for rupees 1 lakh. Property has been sold by A, property X has been sold by the owner A for rupees 1 lakh and sale deed has been executed by A to C in the name of the C, and no information regarding the intention to sell this plot AX. A did inform to the B. B is not having any sort of the information that A has sold his property to C for rupees 1 lakh. And without any information to B, A has sold, not only sold the property but has executed a sale deed for rupees 1 lakh. Sale price of this property is mentioned as rupees 1 lakh. Now, as soon as the sale deed is executed and thereafter it comes to the notice of the B, the owner of the property Y, which is adjacent to the property X which has been sold by A to C, B immediately will get the right of preemption, and meaning thereby that he will be entitled to claim this property X which has been sold by A to C. So he will be entitled to get this property back from the C in the exercise of the right of the preemption, because B, being the owner of a property adjoining to the property which has been sold, had the priority to obtain it first in preference of the others. And without any information, if this piece of the land has been sold by the owner A, then owner B will be the preemptor. He will have the right of the preemption, and in the exercise of the right of the preemption, he can approach to the court of law and can get cancel the sale deed executed in the name of the C, and he will be entitled to be substituted for C for the same price for which the property X was sold by A to the C, and this is called as right of preemption under Muslim law, because here there are two properties, property X, property Y, both are adjoining to each other, they are in conjunction of each other, but under the ownership of the different persons. One owner is X, other owner is B. Now, law of the preemption requires that if A is wishing to sell his plot of the land X, being it adjoining to the plot Y under the ownership of the B, he is under the obligation first to inform B that he is intending to dispose of his property by sale. If without any information to his neighbor B, owner of the property X has sold his property X, say for example to C for rupees 1 lakh, so as soon after the execution of the sale deed, B is informed, and as soon as the information comes to the notice of the B, B will be entitled to claim back the property from the C for the price, and this is called as right of the preemption. This is a preferential right. It is a right of the substitution, means here B will be entitled to be substituted for C for the price for which the property was sold to C by A, and here A will be called as vendor and B will be called as preemptor and C will be called as vendee. So here preemptor, being deprived of his right, will be entitled to revive his right, and in the exercise of the reviving his right, he will be entitled to be substituted for the vendee C, and he will be entitled, and here his name from the revenue record will be rubbed out and his name of the B will be entered, because of the situational existence of the property of B with the property which has been sold. He was having a pre-existing right to acquire this property on being informed. If without being informed this property is sold, then on getting the information he will be entitled to get the property back and will be substituted for the vendee and will be entitled to get it back for the price for which it was sold by the original vendor to the original vendee. This is called as right of pre-emption. This is called as right of the pre-emption or hak-e-sufa. I gave another example. Say for example here, if A the owner of an immovable property, just take the example. A the owner of an immovable property. Say for example, there is a property in the co-ownership of A and B. A is the owner of this piece of the land, immovable property, wishes to sell his land to, say for example, he wishes to sell it to C. If A, the owner of the immovable property, wishes to sell his land to, say for example, suppose he is wishing to sell it to the B, so is the owner of, who is the owner of the adjoining property? Then A is under legal obligation first to ask the B, and B is the owner of adjoining property, then A is under legal obligation to first to ask the B for it. If B refuses to buy that land or is not interested in it, then A may make an offer to sell his land to any other stranger, maybe C. When a situation arises that A sold his land to C without even asking B, then B can exercise his right of the preemption and can dislodge the C from the property by paying an equal amount paid by C to A. This is a very good example. Here, example is that A is the owner of a land. A is the owner of a land. Adjoining to this land there is another land, and the B is the owner of this land. Both the properties are in conjunction. Now, then at any point of the time, if A wishes to sell his land, he is under the legal obligation first to make the offer of the sale to B. If B refuses to buy the piece of the land or he is not interested to purchase it, then A can sell his land to somebody else. Say for example, he can sell it to the C or is sold to the C. Therefore, but if A has sold his land to C without giving any information of his intention to B, then B can exercise his right of the preemption and dislodge the C. He will be entitled to dislodge the C and will be entitled to be substituted for the property which has been sold to him, and that property he can acquire by paying an equal amount paid to C. Means whatever amount was paid by C to A, for that very amount he will be entitled to be substituted subsequently on getting the information. So, this is the right of preemption. This is basic. As per the Muslim law of succession, after a person dies, his property is divided into fraction. Now, suppose that his property, suppose X is a Muslim He dies leaving behind his son S1 and S2. Now, uh, in his property 50% share is of A S1 and 50% share is of the S2. Both are co-sharer. S1 and S2 they are co-sharer in a piece of the land which has been succeeded by them on the death of their father X. Suppose S1 is wishing or wants to sell his land, then he is under the obligation. Law of the preemption requires that first of all he should make the offer of the sale or information of the sale to his co-sharer S2. And if he does not inform or does not make the offer of the sale of his property to S2 and is sold, this property is sold to, say for example, to the C, who is maybe the stranger. So the introduction of the stranger by S1 into this property, which is quite adjacent to the property of the preemptor S2, there is all probability and possibility that C may be a source of inconvenience to S1, S2. And this source of the inconvenience has been created because of the sale of this piece of the land to a stranger. Therefore, in order to let the S1, S2 enjoy peacefully, S2 has a preferential right. He has priority to purchase the land adjacent to his own in preference of the C or anybody else. And if he has been deprived of this preferential right, then it will be the violation of the law, and for this he can proceed to the court of the law and can seek the remedy, and this remedy will be obtained by him in the exercise of his right of the preemption. In case of Muhammad Rashid versus Abdul Rashid 1995, Allahabad High Court defined the preemption under Muslim law as right that gives the preference to the preemptor who lives adjacent to the property being sold or has been sold. It can neither be inherited nor transferred. So, meaning thereby that sale of the right of the preemption can be claimed only in the event of the sale. If the property adjacent to the another property has been gifted or has been given in the bequest, or it is succeeded, has been one has got in succession, right of preemption will not arise. Right of the preemption arises only when one co-sharer has sold his part of the share without informing to the other co-sharer, and it has been sold to a stranger who is going to be a source of inconvenience, and therefore in this case he will have the priority and preference over to purchase the land from the rest of the people or purchaser, and therefore if he has been deprived of it, he can claim it back, and here in this case he will be entitled to dislodge the C, the vendee, by paying the equal amount which has been paid by C to S1, and in this way he will be entitled to be substituted, S2 will be entitled to be substituted for C, and this is the right of the preemption. In the case of Indra Bai versus Nand Kishore 1991, the Supreme Court defined the right of the preemption which arose out of Muslim personal law as a feeble and weak right that could be defeated by law of estoppel. Estoppel puts check and balance on the conduct of the person and prohibits the person from claiming an advantage of his own wrong. The earlier statement made by him cannot be denied at a later stage and strike a fairness of justice.